Hi, Assalamualaikum. We are from Group 6. Today we are going to present it to you guys two legal liability cases. The first case is Billy v. Arthur Young and Co. Robert R. Billy is a plaintiff and respondent. Meanwhile, Arthur Young and Company is the defendant. Billy sued Arthur Young and Company when Young misrepresented Osborne's financial status in audit opinion. So, through this case, we will discuss whether or not the auditor is liable to the client or third party involved in the contract. A supplier of information is only liable to a third party if the information is being supplied for the benefit of one or more third party in a particular transaction classified to the supplier. Facts in this case is Osborne's computer company hired Arthur Young and Company to audit Osborne's financial statement. Young filed audit opinions on Osborne's finance for 1981 and 1982. Billy invested in Osborne based on Young audit's finding. However, Osborne was liable for 3 million greater than what Young reported. Billy brought suit against Young. The jury found for Billy under general negligence, instruction and Young appeal.
Next, let's jump to the auditor liability, which in this case is the liability to a third party under negligence. Negligent misrepresentation is when a defendant makes false claims while sincerely thinking them to be genuine, but without a basis for doing so. Under this case, Arthur Young was professionally negligent in his unqualified audit opinion. This case could be related to Outramer's doctrine that ordinary negligence is insufficient for liability to third party because of lack of privity of contract between third party unless there is primary beneficiary.
Thus, through this case, Arthur and Young Company as an auditor has tried to defend themselves against the legal dispute by the plaintiff by stating that there is actually no duty owed to the third party in this contract. In addition, the court could also defend that the auditor's finding was actually erroneous opinion in which it was done halfly correct and half ambiguous representing the financial statements. It was not completely misrepresentation, though it does stated $3 million less than the actual Osborne Computer Company level 2. Next, let's move to the next part which will be explained in details by my team member Lissa.
Thank you, Afiqah. Now, the part of the principle or concept highlight from this case is that there is a cause of actionable negligence in the misrepresentation or standard holding that the actor and Young Co is responsible for injury to a third party if the information provide false information the third party expect. In addition, the actor considered in evaluating the legal obligation in the absence of contractual privacy between the plaintiff and the defendant, such as the extent which the transaction is intended to affect the plaintiff. So the next part, Ameerah will be explained.
To conclude this case, the court further held that although an auditor may not be liable to the third party for general negligence, an auditor may be held liable for negligent misrepresentation to the third party who are known to the auditor and for whose benefit the auditor has rendered the audit report. So that's all the summary for case study 1. Let's talk about case study 2.
Hedley Byrne versus Heller and Partner. The plaintiff in this case is Hedley Byrne, an advertising company, and defendant is Heller and Partner, and the third party is Easy Power. Through this case, we will discuss on whether or not the auditor is liable to involve in the contract between Hedley and Heller Partners. This case established that it may be possible to make a claim in negligence for poor economic loss where there is a special relationship assuming responsibility between two parties, despite them not being in a contract. Facts of the case is Hedley Byrne were interested in working with Easy Power, a company they had not previously worked with, so they sought a financial reference from their bank. Heller and Partners provided a satisfactory reference for Easy Power, which turned out to be incorrect and inappropriate. When Hedley Byrne suffered losses following non-payment from Easy Power, they sought a claim against Heller and Partner.
Next, let's jump to the auditor liability, which in this case is the liability under duty of care. In this case, plaintiff Hedley Byrne seek for professional opinion from defendant Heller and Partner. They were professionally negligent in his unqualified audit opinion. The relationship was that the plaintiff trusts the defendant with the information and therefore the defendant ought to have been honest. However, on the fact, the disclaimer on the header of the letter said that without responsibility on the part of this bank was sufficient to discharge any duty created by Heller's action.
Thank you, Afifah. Now, I will explain about the auditor's defense in the response to the claims in this case. So, in the rejects of the claim from the plaintiff, in which the plaintiff, Hedley Byrne, argues that the auditor, Hedley Partners, failed to exercise due care, there is a defense could be used as a response against the negligence performance claimed by the plaintiff. The defense is that there is actually a breach of contract privity since the third party, which is a non-party, tied to the contract. Hence, no duty is actually owed to those parties in this situation. The defendant is not directly engaged in the agreement and only responsible if the original party, which is Easy Power, suffered loss. This is also because the duty can only exist if there is a special relationship between the plaintiff and the defendants.
Thanks, Afiqah. So the legal principle that can be highlighted from this case is there was a cause of actionable negligence, which is where there is a special relationship even in the absence of contract, which under certain conditions can give rise to a claim for economic loss in principle. Next, I will pass to another team members, which is Ameerah, to conclude this case.
To conclude this case, the court found that Hedley and partner is not liable. The disclaimer was sufficient to discharge any duty created by Hedley's action. Therefore, the disclaimer prevents the defendant from accruing any liabilities. So that is the end of our presentation. Thank you for your attention.